Welcome, everyone. My name is Mark Enriquez. I'm chair of the Subcommittee to Study Regulatory Change. I'm glad you're able to join me today. Let me start with our Ethics Act reminder that it's the duty of committee members to avoid conflicts of interest and the appearance of conflicts of interest when performing their duties as a member of the Committee to Study Regulatory Change and the North Carolina State Bar. Any member of the committee who's aware of any personal conflicts or appearances thereof with respect to matters before this committee should disclose those at the meeting. Anybody have any conflict of interest they need to disclose? All right, if not, we'll go ahead and get started. I'm actually going to start with some introductions because we do have some new members of the committee. As you know, we've been doing a lot of study and we're beginning to move towards a review of what we've learned, although we're going to be learning more today, including stuff around the needs that we're facing and the legal needs assessment. So the learning process will continue, but we're also going to begin discussing what we've learned, where we want to go, what our recommendations are. And after consulting with the officers and the Chief Justice, I think there was a decision that's probably a good idea to add some additional perspectives as we begin talking about actual potential reform ideas. So from the North Carolina Board of Paralegal Certification, we're adding Lakeisha Chichester. Lakeisha is part of that board. I'll let her introduce herself in just a minute. The other new members we've added are from the North Carolina Justice for All project. You may recall they gave that great presentation to us about the idea of a paralegal certification program. There are two representatives, although they're going to join together to make one vote on the committee. That's Alicia Mercer and SM Hodges. Thank you both for joining us. Since we do have new members too, I thought it might be great to just do a quick round of introductions for everybody so they get to know us and we'll hear from them as well. And why don't I start by letting our new members just give a short introduction. So Lakeisha, if you don't mind starting, just introduce yourself, tell us just a little bit about yourself, and we'll just go around and do that for everybody. It's not as much fun as it would be if we were in person and could actually say hi, but it'll be good for all of us to just and get reacquainted, even for those of us that have been on the committee for a while. Go ahead, Lakeisha.
Thank you, Mark, and hi, everybody. My name is Lakeisha Chichester. I am a corporate paralegal with Family Health International. I am a North Carolina certified paralegal, as well as a NALA advanced certified paralegal in contract administration. I am so appreciative of this offer to join you all here. I'm very interested in this topic to see where the paralegal profession is going to go. So thank you so much for inviting me.
Great. Thanks, Lakeisha. We're excited to have you here. I'm glad you could join us. Alicia?
Thank you, Mark. My name is Alicia Mercer. I am a legal project manager working in Charlotte for Lex Project Management Consulting Group, and I'm a paralegal working for Brown Associates. I'm certified by the North Carolina State Bar, the South Carolina Bar, NALA, and NIFA. And I work as a FINRA arbitrator sometimes.
Great, thanks, Alicia. SM, I'm not sure you're able to unmute from before. If you can, welcome an introduction. But if not, that's fine too. We're excited to have you with us. And I think because of her call-in, I think she was having trouble speaking earlier, but she's also joining us from the North Carolina Justice for All project. And I thought it would be useful for us to just go around and give brief introductions to each other. Again, my name is Mark Enriquez. I'm chair of this committee. I'm in my 9th year as a state bar counselor. I'm a partner with the law firm Womble Bond Dickinson. I do business litigation there in Charlotte. Let's just go. I'm just going to call you in the order I see you on my screen. So Mary Irvine, actually you're next up.
Sure, Mary Irvine. I am the director of the North Carolina IOLTA program. IOLTA makes grants to legal aid programs across the state and have been here at IOLTA with the State Bar since 2014.
Thanks, Mary. And Brian?
Hi, everyone. I'm Brian Oaten. I'm your ethics counsel and staff to this particular subcommittee, along with Alice. I've been with the State Bar since 2007.
Great. Alice?
I'm Alice Mine. I'm the executive director of the State Bar. I've been in that role for a couple of years. Before that, I was Brian. And I have been with the State Bar since 1993.
Thanks, Alice. Jennifer?
Good afternoon, everyone. I'm Jennifer Lechner. I'm the Executive Director of the Equal Access to Justice Commission. We're a commission of the North Carolina Supreme Court, and I've been in this role since 2008.
Thanks. Camille?
Camille Stale. I currently work with Lawyers Mutual Consulting. I have worked in law firms as a litigation paralegal, government relations paralegal, recruiting professional, and business development professional. And I've spent my career back and forth between various law firms and Lawyers Mutual. I'm currently offering consulting services primarily to solo, small, and mid-sized law firms.
Great. Thanks, Camille. Jeff Kelly? You're muted, Jeff.
I must have double clicked there. Sorry. Jeff Kelly. I am an attorney at the Raleigh office of Nelson & Mullins. My practice kind of varies, but it's generally the intersection of emerging technology, complex litigation, and internal investigations. And kind of relevant to this, I'm also the chair of the North Carolina Bar Association's Future of Law Committee.
Thanks, Jeff. Mac?
Mac McCarley. I'm a partner in the Charlotte office of Parker Poe, practicing in the Government and Public Policy Division.
Thanks. Jeff Summerlin Long?
Hey, everyone. Yeah, I'm Jeff Summerlin Long. I'm a teaching associate professor in the Department of Public Policy at UNC Chapel Hill. I'm also a former attorney with both Legal Aid of North Carolina and the North Carolina Justice Center.
Thanks, Jeff. Steve?
Hi, everyone. I'm Steve Robertson. I'm a bar counselor from Greensboro in my 6th year and practicing law 20 years, board certified in the area of family law.
Great. Warren?
Great. I'm Warren Hodges. I'm a program director of a paralegal program at Forsyth Tech. I'm also the chair of the Paralegal Certification Board. And by way of history, because I didn't have sound the first time we did this, I cut my teeth 5 years in legal aid in 2 states before I practiced law and taught overlapping for 12 years. Thanks.
Great. We're excited you could join us, Warren. Heidi?
Hey there, I'm Heidi Bloom. I am a partner in the Raleigh office of Wyrick Robbins. Of course, there only is a Raleigh office, but I just wanted to say that. I am an 8th year bar counselor, and I practice exclusively in what we have come to learn over the past, 6 months that we've been doing this, is an incredibly high demand practice area in terms of lack of access to justice, and that is family law, along with Steve and Marcy, who I see on here somewhere. So.
Great. Thanks, Heidi. Colin?
I'm Colin Willoughby. I'm a lawyer in Raleigh. I practice with McGuire Woods in the government investigations and white collar crime. I'm the immediate past president of the state bar, and I think I started trying cases in courts about 2 years before Brian Oaten was born.
That's good. Marcy?
Hi, I'm Marcy Armstrong, and I practice law in the Armstrong Law Firm in the Smithfield office, which is the only office we have. But I am a family lawyer, and I appreciate everybody's service on this very important committee. And I'm the vice president, of the State Bar.
Thanks, Marcy. Ashley?
I'm Ashley Campbell. I'm a clinical professor at Campbell Law School. I'm a former Legal Aid of North Carolina lawyer and passionate about issues of access to justice.
Awesome. Josh?
Joshua Malcolm. I'm on the road traveling today, so apologize for the background. I'm from southeastern North Carolina, Robertson County. I serve concurrently as the CEO of the Holdings for-profit company for the Lumbee Tribe, and also serve as in-house counsel for Lumbee Tribe Enterprises, which is owned by the tribe itself. Thank you.
Thanks, Josh. Thanks for making the effort to join us. Barbara?
Thanks, Mark. Hearing all these introductions reminds me what a great committee this is. Barbara Christie and I practice with the firm of Shell Bray in Greensboro. My practice is primarily commercial real estate, and I am currently president of the State Bar.
Thanks, Barbara. And Todd?
Mark, first I want to say apologies for being late. I'm literally between 2 or 3 meetings, so I apologize for being late. I guess you guys are doing introductions. Todd Brown, I'm a partner down in Charlotte with the firm of Hunter and Andrews Kurth. Commercial litigation is my primary practice, and I've been involved with the State Bar 10 or 11 years now. Thanks.
Thanks, Todd. Did I miss anybody? I know I see one person showing up as iPad, but I think we may have already heard from them. I think we've got everybody.
I don't think we introduced Colonel Hodges. If she can't introduce herself, I can introduce her.
That'd be great, Alicia. Thanks.
Okay. Colonel Hodges is a paralegal, and she is also a legal project manager at Tolliver, Richardson, and Colonel LLC. She worked in law enforcement in Virginia for 10 years before moving to North Carolina, and she is co-author of the Justice for All project with me.
Awesome. Thank you for doing that, Alicia. I appreciate it. No, and I had the same thought Barbara did. Wow, this is an impressive group. I'm excited to have this group together. I mean, we've got, as you can tell, a lot of different folks from academia, paralegal work, legal work, all around the state, different size firms, different practices. So I'm excited. And I think that's how we build the best decision making, is really, with a broad representation of people coming from different perspectives, trying to see if we can work together to identify ways to make the system work better for everybody, and do our job as a state bar and identify those areas. Again, the mission of our group is to study areas where regulatory change can make a difference for equal access to justice. And we're going to hear more about that in a few minutes, but we've got a lot of needs out there. So we're really trying to figure out what can we do to improve the situation? How can we better serve the people of North Carolina? From our perspective as a state bar, what regulatory changes can we make that will improve things? And we've learned about a lot of different options. I'm really looking forward to our dialogue on that. Let's go. What we're going to do today, we'll do the minutes now, and then we're going to briefly review our survey results, but then we're going to turn to the presentation from Jennifer and Mary on the Equal Access to Justice Commission. Let's get the administrative piece out of the way first, though. Brian did attach as part of the agenda the minutes from our March 23rd meeting. Anybody have any changes or corrections to those? If not, I'd entertain a motion to approve them.
So moved.
All right, that's motion by Jeff.
Second.
And seconded by Steve. All those in favor indicate aye. And I guess, Brian, we'll use our voting buttons on this, or do you want a consensus?
Yeah, I mean, I think this is one that we can do a voice vote.
I don't think it'll be close. So yeah, if you're in favor of approving the minutes, say aye.
Aye.
Any noes? I think they are unanimously adopted. So I'm not sure all our decisions will be quite that easy, but we'll start with the easy ones. As you know, we sent out a fairly long survey because I really wanted, now that we've spent several months learning about different things, I wanted to kind of take the temperature of the committee on where we were. Again, it's not binding on any decision making, but it was really, where are we? Is there a consensus emerging? So thank you for taking the time to do that. Brian, why don't you give us a short overview of the results of that survey we did of the committee members?
Sure, and I'll go ahead and share my screen and make sure everybody's seeing the results here on the screen. Like you said, Mark, it was a lengthy survey, and we certainly appreciate everybody's response there. But I think it was pretty telling about what we have here and what the subcommittee members are feeling, how they're feeling about these different ideas that we've been studying over the past couple of months. So as you can see in the materials, there's kind of a screenshot essentially of what the results were, combined with the comments that some folks typed in about that particular idea. And overall, I think you can go through each one of these individually, but I'm going to just go down to the very last slide that reflects the different results. So I think that tries to kind of cumulatively talk about what we are looking at, what the results were. And you see that the limited license idea, I think really is received the strongest votes along with court navigators. Those are the two ideas that the subcommittee indicated were either full on, yes, we should support, or kind of a maybe we should support, continue discussing, but clearly there's a positive feeling there. UPL liberalization came in kind of, I guess if you call it a second place, if those first two came in tied for first. The second most popular idea was UPL liberalization, which I think, based on some of the comments as well as just the concept, there's some realization that if there is a limited license, that would require some liberalization of those UPL rules. There would be some statutory changes that need to take place, as well as perhaps some an examination of the rules of professional conduct, particularly under Rule 5.5. Alternative business structures and exactly how firms can operate. Can they combine with other services to, we've heard the term kind of the one-stop shop, perhaps that you would go for domestic legal services. Perhaps there's some sort of therapy session that's or mental health component that needs to go in or taken into consideration. As well as looking at the regulatory sandbox, you see there's some positives and a lot of maybes on those two ideas. I think because you'll see that there's a lot of questions, particularly with the sandbox, on resources. Exactly what extent this could be either a limited thing or a very, very broad idea, particularly with the sandbox. Sandbox is a really intriguing idea, this notion of creating essentially a pilot project for the entire state where other businesses that ordinarily could not practice or could not offer legal services in North Carolina would be allowed to do so under very close watch from the state bar or some other entity that gets set up to really watch over, accumulate that data, to be there to receive any sort of complaints and really check in with the clients that are served by those services. You can see down at the bottom, fee sharing with non-lawyers, alternative admission to the bar, and non-lawyer ownership did not receive as strong votes from the subcommittee. So really I'd say, that last slide is kind of a good thing to look at when you're trying to sort out where exactly is the subcommittee standing on these different ideas. I will say that one of the other questions that we had was, first, do you think the state bar should support this? But second, do we need to know more? And generally speaking, it seemed like the subcommittee was indicating for most of the topics that the subcommittee feels confident that they know enough, or at least a majority of the votes were cast saying that they know enough about the topic to be able to make the decision and move on. So that's going to be something, Mark, I know we'll be talking about later on after the presentation, but that's the overview of the survey at this point. And I guess I'll send it back to you, Mark.
Thanks, Brian. No, I think that's really helpful. I appreciate that review. And my plan is, after we hear from Jennifer and Mary, I would like us to have a discussion about those results and kind of a discussion about where we want to go from here. Because I think our end result is going to be a report back to the Issues Committee saying, these are the ideas that we recommend you look into, and maybe here's some of the aspects to consider. Again, our charge was not to develop a final proposal that's going to be voted up or down, but rather to identify the areas that we think are worth exploration. So I think we'll dig into that discussion and kind of talk about the process and what other information we want as a committee afterwards. So you can be thinking about that as we hear from Jennifer and Mary. But I thought it would be useful, particularly in light of the recently released assessment, to remind us of the need we're trying to address as we consider what alternatives may help us get there. And that's why I wanted Jennifer and Mary to come and talk to us about that needs assessment. So with that, let me turn it over and Jennifer, are you going to take the lead on it? Or I don't know how you divided it up, but I will let you guys take over and tell us more about where we end up with the needs assessment.
Great, thank you, Mark. And I do have the first part of this. Let me share my screen here. Get this up. All right. You would think that after 15 or 16 months of doing Zoom presentations that I would be better at managing both the slides and the squares where you all are located. I am not, sadly. So please, I'm hoping this can be as much of a conversation as it is a presentation. It's hard, I know, via Zoom, but please interrupt. Currently, I can only see just a few of you, but I'm going to try to expand this and do a little bit better here so I can have a better view. As we noted in the introductions, I'm Jennifer Lechner. I'm the Executive Director of the Equal Access to Justice Commission. I'm really grateful to be here today to talk with you both about our legal needs assessment that we just launched in April, but also to talk with you about some possible opportunities for North Carolina. I think this is a really exciting time. It's really propitious that this committee is meeting at this time when we have the legal needs assessment and when we have lots of stakeholders in our justice system talking about how we can improve things for those who are trying to access it. So this is great timing, and obviously an illustrious committee that you've got here to help us solve some of these access to justice problems. I'm going to turn it over to Mary Irvine, but before I do, before I get through my slides and get to Mary's part, Mary's the Executive Director of NC IOLTA. She's been a terrific partner with the Access to Justice Commission, along with the State Bar and others in this. And I do want to mention that NC IOLTA was a funder of this legal needs assessment, along with the North Carolina Bar Foundation. So there we go. I don't usually encourage folks to look at other screens when I'm talking, but this is a time when you have leave to do so. All of this information that I'm going to give you and that Mary is going to give you can be found at nclegalneeds.org. We've got the executive summary, we've got some story maps, and we have 100 county profiles of socioeconomic information and some legal needs that we are highlighting for each county. So I hope that you will take a look at your local jurisdiction and see what the legal needs are there. It is different throughout the state. It was fascinating to me to learn the differences and not always where we thought that they would be. So I hope that you will refer to this throughout your consideration as this committee. The legal needs assessment really has been talked about now probably for over a decade. I've certainly been involved in those conversations for about that period of time. This was our steering committee for a number of reasons, and maybe the same reason that this regulatory subcommittee was formed. The time just seemed right. We had some funding in place. We had some real energy behind it. We had terrific leadership from Justice Earls of the Supreme Court and other members of the judiciary. But we also had a very engaged steering committee where we had legal aid providers, a representative from Wake Forest Law School, members of the judiciary, the private bar, and funders who really came together to help us put together this legal needs assessment. And just to give us some context here, we know this. I'm not telling you anything you don't know, that criminal defendants have a right to counsel. There's almost no civil right to counsel in the United States, and that's certainly true in North Carolina. We also know anecdotally, and our experience tells us that a large percentage of the population in North Carolina cannot afford the services of a private attorney. And so thousands of people are left to navigate complex civil issues without representation. And so what we're talking about really are basic human needs. We did not seek to study personal injury cases or eminent domain. We were really looking at cases that impact the most vulnerable of our population. So in 2020, again, through a grant through NC IOLTA and in partnership with UNCG's Center for Housing and Community Studies, we worked with the Equal Justice Alliance, which is our coalition of legal aid providers, to undertake the first comprehensive civil legal needs assessment in North Carolina in almost 20 years. So it had been almost 2 decades since these issues had been studied. We had 2 primary goals. So we wanted to document the current resources and services available to meet civil legal needs. And we wanted to understand what the gaps were in services and where the gaps are in services and what resources are needed to address unmet legal needs. And so that last part about what resources, what changes are needed is going to be part of what we discuss here today. Just to give you some fast facts, again, to provide some overall context before we dive into the North Carolina legal needs assessment. Most of these are national stats, but a couple from North Carolina. In 2018, we had over 2 million people who were eligible for the services of legal aid providers. National studies show that 71% of low-income families will experience at least one civil legal aid problem in a given year. We've got a large subset of that will also have more than one in a given year. 86% of those legal needs go unmet because of limited resources for our legal aid providers. And there's one legal aid attorney for every eligible 8,000 North Carolinians. And those are eligible for legal services. So that's usually about 125% of the poverty guideline. And that's one private lawyer for every 367 North Carolina residents. Our UNCG researchers, I can't say enough good things about them. They just did a terrific job on this very comprehensive study. What we are doing is really dipping our toes into the research that they provided us. The final report is over 380 pages. And so we're gonna try to condense that down for our purposes today. But it really was incredibly comprehensive. They collected and analyzed data. They had 28 in-depth interviews. And then overall, they did surveys with almost 2,000 people. So both stakeholders in our justice system and past, current, or potential clients. We were also fortunate to partner with the Equal Justice Alliance and our 8 civil legal aid providers so that they could give us a snapshot of their caseloads in 2019. The UNCG researchers also were able to obtain data, the civil case data, for the 2015 to 2019 period for 26 civil issue case types. And I want to draw your attention back to these civil case types. Again, we didn't survey all civil case types that might come up in a North Carolina court system, right? We took those that we thought would be most experienced by vulnerable populations and that legal aid routinely sees as part of their practice areas. We also, this does not capture things that happen in federal court, things that happen administratively, things that happen in immigration court. So this snapshot that we're providing you here today really is limited to our state civil justice system, but I do think that we can draw a lot of inferences from that. I'm going to pause there and see if there's any questions. I do see, I see we have a question about getting the full version in electronic format. Absolutely, Jeff. I'd be happy to email that to you afterwards. We don't have many people ask for the full 380-page report, so I'm grateful.
I'm an academic, so.
Good. Well, you can geek out with me then on the numbers. This is a really terrific report. Any other questions or comments so far before I move on? Okay. There we go. So our primary findings, and again, I don't think any of this is going to be a surprise to the folks on this call. We've been talking about this for months. You had me on several months ago to talk about access to justice and civil legal needs in North Carolina. And that message really hasn't changed, but now we've got the data to back it up. So that's what I'm presenting to you here today. Low-income North Carolinians face a severe shortfall in affordable legal services. Yes. Some of the resources have increased, but so has our need and so has the diversity of our population and the diversity of our vulnerable populations in particular in North Carolina over the past 20 years. We have some populations that we found that were underserved, even relative to the larger population of low-income people, notably veterans. And we'll talk about veterans as we go through. They came up as an anomalous demographic throughout this survey. And we also have, and we're going to talk with you about this as well, the Legal Services Corporation restrictions to serving, those who are about 125% of the poverty guidelines really eliminates legal aid as an option for a huge swath of our more modest means, middle income clients who also need representation. So they're ineligible for legal aid assistance, but they can't afford a private attorney. The other thing that we learned that we also knew anecdotally is our legal aid providers are forced to turn away many eligible people who have meritorious cases because of the lack of resources. This has already been mentioned in the introductions, but family law, particularly custody proceedings, is by far the most mentioned area of underserved practice. The second was immigration. We're going to dig a little bit deeper in that as we go through the presentation. We also discovered that if we could funnel additional resources into more routine practice areas like expunction and traffic law, it has the potential for tremendous impact in folks' lives to be self-sufficient and really be productive citizens. So again, I will pause there for just a minute. Are there any questions so far? All right. 91% of clients named costs as a barrier. We're going to talk about some other significant barriers, but 91% named costs. That was far more than I thought that it was going to be. A lack of internet access, as we talk about systemic changes, other things that we can do. Lack of internet access really harms the ability of low-income communities, rural communities to access legal aid. Our legal aid providers just aren't able to get into all of the places in North Carolina, and a lack of internet access, hampers their ability then to access them remotely. And the need is only growing. Poverty, especially, I don't recommend undertaking a statewide civil legal needs assessment during a pandemic, but here we are. And one of the things that was revealed, which again is not a surprise, is that things were bad before, and the pandemic has really exacerbated that. And so we are going to continue to see the fallout, I think, from the pandemic, the loss of employment, the loss of housing, and loss of educational opportunities for months and years to come. So I'll turn it over to Mary now, unless there's any questions for me. All right, Mary?
Sure. Okay, I'll jump in. So the legal needs assessment included a review of the economic conditions in North Carolina. I think there's a sense that understanding that context is important to understanding what is facing the eligible populations, the low-income populations that are without legal services to meet their needs. So this slide provides that top-level overview of findings. Nearly 1.5 million North Carolinians, 15% of the state's population, live in poverty, and that Black households are disproportionately experiencing poverty. Prior to the pandemic, the median household income in North Carolina was $52,413. That's almost 50% of households that have an annual income of less than $50,000 per year. Prior to the onset of the pandemic, 3.5% of workers were unemployed, but in the midst of the pandemic, of course, that number shot up to close to 13%. Most recent figures show that number between 5 and 6%, remaining higher than pre-pandemic levels. And lastly, 20% of homeowners and 44% of renters are considered cost burdened. This means they spend more than 30% of their income on housing. Of course, spending more on income means that there is less for other necessities, food, medical care, childcare, and other essentials. Next slide. So case data was provided, as Jennifer mentioned, by the Administrative Office of the Courts for a select number of case types. This does not represent every case type that goes through the court, but 26 civil issue case types were chosen based on their particular impact on the poverty population. So the data shows the need in terms of the filings, the volume of filings in the court for civil cases each year. The data was provided for a 5-year period, but then it was annualized. You, of course, would expect to see higher raw numbers of filings in more populous places across the state. So the research team did analyze the data to get to a rate of case filings per population to demonstrate the geographic parts of the state where there are higher rates of case filing when that population is taken into consideration. So the map shows the rate of civil cases per 10,000 people. The highest overall rates are shown in the dark blue and the green. Most of the counties with higher rates are more populous: Mecklenburg, Wake, Durham, Guilford, New Hanover counties. Those you might expect more access to resources, more companies that are also there, more access to legal services. But you'll also note that some of the counties in blue and green that are that have among the highest rates of case filings are much less populous. That county in the top that you see, the top right, is Pasquotank County. Jones County, Vance County have very high rates of case filings. The researchers did note a few trends in the rate of particular civil case types in certain geographic areas. One example they noted, foreclosure-related cases were less correlated with population density and were highest in some of the eastern and western counties, as well as in Guilford, Forsyth, Polk, and Cumberland counties. Foreclosures represented about 10% of the AOC data filings. Domestic violence cases were also more concentrated in the western part of the state. Next slide, Jennifer. This slide looks at the data provided by 8 of the legal aid organizations. They shared data regarding their casework during 2019. So we see here sort of a snapshot of the volume and the types of cases that the providers closed. About 34,000 cases were closed, serving 93,000 people. Domestic violence cases represented 23% of those closed cases, approximately 7,600 cases. Private landlord-tenant disputes represented another 15% of the closed cases, a little more than 5,000. I would expect that the 2020 number is higher than the 2019 number in that category. Another 5% of cases involved federally subsidized housing, and then immigration represented 3% of the closed cases, about 1,000 closed cases. We'll talk a little bit more about some of the outcomes that you see there on the next slide.
Can I just interrupt for 1 second? I'm sorry, Mary.
Sure.
Which 8 legal aid agencies are these?
Yeah, so I couldn't tell you the list because I'm going to end up missing
Okay.
one or adding one that was not there. But Legal Aid of North Carolina is the biggest of the agencies represented here.
So that's just one.
Yes, just one.
Okay.
So Pisgah Legal Services, Charlotte Center for Legal
Okay.
Advocacy, Land Loss Prevention Project, Disability Rights North Carolina. I'm going to miss someone, like I said.
Justice
but
Center.
just to give you a sense.
Okay. Yeah, I wasn't sure if Lank was going to count as one, or
It does. It does count.
that kind of thing.
Yep.
Sorry.
No, sure. So on the next slide, there is sort of a comparison between some of the AOC data that's provided and the data provided by the legal services organizations. I want to just acknowledge at the outset that making this comparison is imperfect. Go ahead and say that because it's not perfect, but it does give us some ability to make some meaning about what we see here. So of course, on the court data side, it's not going to take into account that some folks are represented by private attorneys. This doesn't take into account that some of these cases drop off, that they are filed and then are resolved in another way. On the provider side, it also doesn't take into account the brief services that are provided, and again, cases that are resolved in some other way. But I think the comparison does attempt to just make some meaning of the services that are provided in light of the potential need. So the number of people facing these issues as documented by the court filings compared to the number where a legal aid program was able to both provide full representation and then get a positive outcome. So you see here 1% of, there were approximately 1,900 evictions prevented, and that represents 1% of the summary ejectment actions that were filed. Similarly, 284 foreclosures prevented with over 23,000 filed. And then in the domestic violence realm, there were close to 33,000 domestic violence actions that were filed, about 3,000 protective orders that were obtained, about 9% of those, where a legal aid program was able to obtain or work with a client to obtain a positive outcome. So we can talk about what exists there in the middle, but there's a gap. Undoubtedly, I think it's fair to say that there's a gap. All right, so cost, as Jennifer said, far and away, cost was documented in the legal needs assessment as a top barrier to legal services for eligible populations. This was nearly universally acknowledged, with 90% of folks indicating that cost was a barrier. But there were other barriers that were documented in both the surveys and in the qualitative research that was done. A few that I would highlight: the need to take time off work. missing work days, or only scheduling appointments when someone already has a day off. That was considered a significant barrier. One person explained this by saying 1 day's loss of a paycheck could be the thing that keeps them from being able to eat for that month. Another individual saying keeping their job is going to be a priority over going to meet with an attorney. For individuals who are living in rural areas, they may face additional barriers to accessing those services due to public transportation and the lack of a legal aid office that is close to them. In the research, there was agreement among lawyers, the social service providers that were interviewed, and clients alike that many folks are more isolated in rural communities. They might not have heard about the free legal services that are available. They might not have dealt with an attorney before at all, and they don't know who to call. Next slide goes back to a point that Jennifer made in the review of the primary findings. The legal needs assessment documented this gap that exists for those that make more than the threshold that's set to qualify for free legal services, but without sufficient income to pay a significant retainer. I think this is consistent with studies of wealth generally, that there are individuals that can't really afford an unanticipated expense. There's not savings, there's not a cushion that's been built up to support that. This is one of the populations we hear about frequently. For the providers, they get calls from these individuals. You probably get calls as folks that work in communities and talk to folks. And there's a sense that there's just not many resources that can assist this group that's in the middle. The perception may not always match the reality. Maybe a lawyer could help them with some parts of their case at a level that would be affordable, but people don't think that they can afford it for sure. Lack of trust was another element that was studied as part of the legal needs assessment. The study asked participants, including both survey respondents and also those that participated in focus groups, to rate their level of trust in lawyers. As the slide notes, the average is about 63 on a scale of 0 being no trust and 100 being total trust. So of particular importance here, higher trust was seen in respondents with higher incomes. Veterans had lower levels of trust. There was some further focus group discussion as well, where people highlighted that low-income folks have had experiences with the court system that might increase their distrust. Some communities, immigrants being one, may have particular cultural beliefs or fears that are related to the justice system and to attorneys in general. And then the next slide goes over the categories of legal services that were noted with high needs. You would be correct if you look at this slide and note that it covers most of the areas where legal aid work occurs. It's housing for both owners and renters, family law, immigration, senior law, healthcare, income and benefits work, consumer rights. These were all of the categories that were identified as having the highest needs by folks, both clients and also lawyers that participated in the surveys. And then this slide, as Jennifer noted, the IOLTA program did provide a grant to the Equal Access to Justice Commission and the Alliance to support the study, as well as support that was received from the North Carolina Bar Foundation. And the research was conducted by some great folks at UNC Greensboro. We worked over maybe a slightly longer period of time than was initially anticipated due to the pandemic, but really appreciate all the folks that served in numerous capacities, from the steering committee to all the folks that responded to the many requests to participate in interviews and surveys and things like that. So that's sort of our overview, and then we're going to move into the next section. If there are any questions, happy to take questions and then turn it over to Jennifer.
Before we start with the opportunities, and really I think probably why we've been asked to be here today, are there any questions about the data that we've presented in the legal needs assessment, or anything that we didn't cover that you perhaps expected to see? Okay.
I don't have anything that I expected to see, but I just wanted to mention that I had a senior honors thesis student this year write about access to immigration legal services in North Carolina. And it's mostly a qualitative, research project, but she reached out and talked to people all over the state. And, if we do in fact go and talk specifically about immigration stuff, I'm sure that she would be fine with me sharing that with you, because there are some interesting findings in there. And so just wanted to throw that out there.
Great, thank you, Jeff.
Thanks, Jeff.
Great. Okay, so the next part of the conversation that we want to have with you is opportunities. And the background of this is the survey that Brian presented earlier that Mark was talking about. We were looking at ways that we could use this really important information from our legal needs assessment to inform the policy considerations that are before this group and perhaps before the state bar more broadly. And so what we are going to talk to you about today, Mary and I have really tried to focus based on your survey results and paired again with the legal needs assessment. So before I do that, though, I have to give the appropriate lawyer disclaimers, which include that resources are at the heart of access to justice, and so that the ideas that we're going to share with you today are not necessarily those, but ultimately a well-funded justice system is one that is going to operate better for the citizens of North Carolina, and that includes all of the justice system stakeholders to be well-funded so that they can do more work, right? I mean, that's somewhat self-evident. More resources, more legal aid attorneys, more resources within our judicial system is a benefit to us all. So I would be remiss if I didn't start by saying that. I also want to note, and again, this is self-evident, but I think bears repeating, that these are legal needs that often reflect broader systemic issues. And I'm going to touch on those a little bit because I want you to hear from some of our stakeholders who were interviewed and what they offered as changes to the system. So these are solutions that are incredibly complex, right? There's never any one right answer to this and one way to solve it, but we are here to see what we can do with the state bar, and just as we are meeting with other justice system stakeholders to see what their contributions can be to helping to bridge this access to justice gap. So we've really focused on kind of what can the state bar do here. So I also want to note that this report, very intentionally, documents the need and documents resources available. What the report does not do is suggest recommendations. I did not view that as really within our mission from the Commission and Alliance standpoint. We were very careful to try to stay in our lane and not advise other bodies about how they should govern themselves in the profession. And then I'm going to break that rule immediately and tell you maybe some things that the state bar should do. But these opinions are offered only as my own and suggestions only as my own and as Mary's in our individual capacities. NC IOLTA certainly isn't going to endorse, nor will the Equal Access to Justice Commission, some of the things that we're going to talk about today, at least not yet. This report was just released in April at a special meeting of the Access to Justice Commission. And the truth is we just haven't had a chance to meet yet to talk about additional policy recommendations that might flow from this. So don't get me in trouble. And
I co-sign on all of Jennifer's statements.
And we will take those comments as intended, right? These are your personal thoughts based on your experience with this work. So
that's right. And looking at what other states have done and listening to what other states have brought before you. I mean, I have watched every single meeting that you've had. I'm fascinated to learn and to hear really from folks on the ground in other states like Arizona about how they're making things work for them. I've also been obviously part of the national conversation on these issues for 20 years now. And so I'm hoping that we can bring some of those models, those experiences back to North Carolina. So with that, these are the topics that we want to talk with you about today. And I can't get this to advance. There we go. So as Mary and I have pointed out, right, from the legal needs assessment, some of the highest area of needs, right, we saw were housing for owners and renters. Again, family law keeps popping up. We know that that's there. And then to Jeff's point, immigration naturalization issues were also the kind of the top 3 identified areas of need. And so we were looking at some of the opportunities here in North Carolina, whether that's simplifying court processes, other technology, the use of court navigators, the use of a limited licensed technician, paraprofessional, whatever you want to call that, so that there were some opportunities there. So that's what we're going to talk with you about now. So online dispute resolution is something that has been done in a number of other states. And I think that I've always been sort of fond of it, but I think particularly now in the middle of a pandemic, we've seen that we can conduct business, maybe not as exactly as we would like, but it is efficient to do things virtually like this online. And so you can have the synchronous, as we're doing now, online dispute resolution, or you can have an asynchronous model. There's many ways that we can look at that, but as we look at some of the survey respondents, barriers to access, right? They said cost. They said missed work days. They said lengthy legal process. If we can engage in other activities like online dispute resolution, we can mitigate, if not resolve, some of those issues that they described as barriers to access. So the National Coalition for Civil Right to Counsel finds that about 3% of tenants have counsel, compared with 81% of landlords. This creates a tremendous power imbalance. And what it means is tenants don't show up. They may have a legitimate defense, but a lot of times they're just not going to show up. They just don't believe they have a fair shake. They can't, again, go back to the, can't take a day off work. It's going to be too long. I can't sit there all day. I don't have childcare. I don't have transportation if I'm in a rural area. So Arizona in particular has had a notable increase in hearings related to evictions since they started holding their hearings online. And so before, in one jurisdiction, they had 90% of defendants who didn't show up. They would just default. But since they've gone virtual, the participation rate has skyrocketed to 80%. And I think that's really an impressive statistic that shows that meaningful participation both helps with the cases themselves, but it also helps to preserve public trust and confidence, right? I always include the slide about lack of trust that we heard from a number of survey respondents, because I think as a profession, we need to be really concerned about that. That is not in our favor long term. It is hard to maintain the system of justice if we have such a deep-rooted lack of trust. And so the more people who feel like they can show up and meaningfully participate and get a fair shake, the more we are going to reinforce that public trust and confidence.
Can I ask one question real fast? I'm sorry, Jennifer.
Go ahead.
I mean, that's a impressive, jump from 90% not showing up to 80% showing up. I do worry to a certain extent, comparing Arizona to North Carolina and that kind of thing of, well, the 20% that didn't show up, is that because they didn't have access to the internet? Right. And so there's these systemic things that we have to bring into the fold before we, start making recommendations.
Absolutely. And Jeff, that is a perfect example of there's not one solution, right?
I know, right. Yeah, I know. I'm sorry to complicate things.
Online dispute resolution can be really helpful. Look at these great numbers from Arizona, but you're right, it only works if people have meaningful internet access, not just access to justice, but internet. So yes, I think these are all things, to be considered and maybe even piloted if we wanted to think about other options to test them out here. And all of the models I'm going to give you are not going to be, directly transferable to North Carolina. We'll have our own things that we'll need to work through here statutorily or regulatory or otherwise. But I think they're ideas. I think we can draw from them. And I think the pandemic in particular has given us some real opportunities for change around technology and what we can accomplish online.
Jennifer, for online dispute resolution, if we decided, that was a good thing to address this issue, are there things from a state bar regulatory perspective, either rules that inhibit online practice or things that the state bar could do to encourage or facilitate online dispute resolution? Have you ever looked at that at all?
Yeah, I'll turn to those who.
Okay. All right. Sorry, I'm anticipating.
Alice, yeah. I feel the same way. We're going to talk about court navigators. I'm not sure if that was one of the identified areas that this committee came up with as further interest that may have a regulatory component. I can certainly see that there might be here, but I couldn't point to a specific rules change for you, Mark. Yeah, Steve just posted a great comment in the chat too about New York. There's many states that are working on a variety of, again, ways to make this more accessible and address a lot of the concerns that we have heard from our stakeholders in North Carolina. This is great. I certainly don't want to cut off this conversation and move forward. Any other comments? Okay. So I'm actually procrastinating going into this next slide because I've got so many family law experts here and I will show my woeful ignorance. But one of the things that we saw from the survey results and one of the things that we've heard from other states is a less adversarial process. And so is that encouraging a more collaborative family law model, right? We know that high levels of parental conflict is toxic for children. We don't know how many self-represented litigants are in North Carolina courts. North Carolina does not keep those statistics yet. They will be kept with the new integrated case management system, but we don't know that right now. But we know the data from other states is about 70 to 85% of parties in family law cases are unrepresented. This is a burden on the court. This is a burden on the system. And it's really difficult to try to navigate through these issues. So changing how we operate family law, again, there's, I think, some opportunities here as well, both for a process change, but also through other kind of intermediary support systems, whether that's a navigator, whether that's a limited licensed technician. There's some other things there as well. Housing specialists. So Massachusetts has an entire housing court where they have 33 housing specialists and 15 judges who hear their housing cases. And really the housing specialists are far more of a mediation philosophy, collaborative environment, problem-solving court is how their chief judge described it to me. Instead of, showing up with a landlord who's represented and then a tenant who is not, and really trying to get through, they have 40,000 housing cases in Massachusetts a year. And so they manage this really high volume to try to make it less adversarial, but still preserving the rights of the landlords and the tenants. So there's some opportunities there as well. Mandatory mediation, and I know we have it in some cases. In Maine, it's required in small claims, eviction, foreclosures, family matters, and some other civil cases. Again, it is a way to try to resolve issues, problem solve early on in a case before it gets further along, before it becomes more adversarial, before it becomes too costly, and to get people to resolve their issues in as efficiently and hopefully as just a way as possible. My colleagues would be very disappointed in me if I didn't mention pro bono. Again, this is another area that is, I think, a piece of the puzzle. Pro bono in North Carolina is growing. We're really, we have a lot to celebrate with our pro bono culture currently. I wanted to share these important stats with you and celebrate with you the great work that our profession is doing So we had over 1,600 North Carolina lawyers report their pro bono activities for 2020. Of these, we've got almost 600 who provided more than 50 hours of pro bono. And that's, almost 68,000 hours of pro bono completed in 2020. So it is a great example of an activity that should be expanded, but can't possibly meet all the civil legal needs. But again, it is one important piece of the puzzle. Some ways that the State Bar may want to consider increasing pro bono participation, CLE credit for pro bono, developing additional resources to support pro bono activities. It is really a challenge for our legal aid providers to support pro bono and to leverage pro bono attorneys. You've got to set the case up, you've got to train the attorneys, you've got to mentor them through the process, you've got to do all of the screening and reporting that comes with that. Some things that other states have done are mandatory reporting of pro bono hours. It's voluntary in North Carolina, and you can see, I think we've got 29,000 lawyers in North Carolina, and we had about 1,700 report in voluntary reporting this year. Or mandatory pro bono. There are other models of, you have to provide a certain level of service. I understand, and again, this is where this is an offering, not even a suggestion, how unpopular that might be. But if we want to encourage greater pro bono participation, that is certainly on the table. And so again, I want to call your attention to the barriers to access. We've had this conversation many times throughout this presentation so far. But this is what our stakeholders told us, right? These are what clients, past, current, future, that population told us were really their barriers to access. And so as we're looking at regulatory changes, as we're looking at promoting things like greater pro bono participation, we also have to have these considerations in mind. And so I hope that, as we continue to think about this and to formulate ways forward, particularly for the State Bar, that's our purpose here today, that we also keep these in mind too, that we're going to have to continue to advocate as a profession to really partner with other stakeholders in the system to make sure that we have a reduction in these types of barriers here. Okay. So to that point, I wanted to share with you, and again, I'm not even offering these, I'm just sharing what our study participants said. So all of our study participants were asked, what changes would they like to see at the local, state, or federal level? And so this is what they said that would be helpful to them. And again, these are complex systems, these are complex problems, but I think it is only fair to share with every audience the information that was provided to us as far as other significant policy changes, whether that's Medicaid expansion, greater resources for legal aid providers, increasing the minimum wage. I mean, these are all part of ameliorating poverty and helping to provide greater access to justice. So I will turn it back over to Mary unless there's any questions for me. Okay.
Great. As Jennifer noted, the gap identified in the legal needs assessment is complex. It is multifaceted. The opportunities for making improvements are wide-ranging. You saw some of those on the past couple of slides. So we're going to move from the opportunities that she reviewed regarding simplifying court process, pro bono, a host of other kinds of systemic changes, to changes that might specifically involve regulatory reform, including many of the opportunities that this group has talked about. Heidi, I think you said over the past 6 months, it's been a year. I checked my emails as I was preparing for this and thinking about some of the presenters that have joined the group. It's actually been a year that the subcommittee has been meeting. So the first of the opportunities are paraprofessional models. I believe this group has heard from a couple of jurisdictions which have rolled out new categories of licensure, and has also heard some updates from others about either rule changes or proposed rule changes happening in other places. Each state seems to have their own name to describe this group: limited practitioners, limited licensed technicians, legal assistants, legal document preparers, licensed legal advocates was another one that I saw. For our purposes, I'm going to talk about paraprofessional models and models of utilizing different capacities of paraprofessionals to add to the continuum of services that can be provided to individuals that need legal services. This quote here came from the Colorado Supreme Court Subcommittee on Paraprofessionals and Legal Services that provides some framing, which I think is true for how other states have framed their efforts as well. It's aimed at providing more choice and more opportunity for a range of services. Instead of the choice being between representing yourself or hiring a lawyer, it's also offering another choice for assistance. One of the criticisms I've seen, I think this group has talked about, and I think it goes to somewhat of the reframing, is the idea that the licensure of paraprofessionals would create a two-tiered system of justice. It seems to me that this criticism presupposes that there's adequate representation that's already available. What we know, what we already knew, what this study further fully documented and more specifically documented, is that adequate representation and assistance is not available to many low-income people. And because of that, you could say that we already do have a two-tiered system, or at least some perception of a two-tiered system when people are not able to afford that assistance. I guess I would also bring back to your attention the earlier slide about the middle income category and those folks who find themselves ineligible for legal aid but perceive that they're priced out of the services that private attorneys could provide. This to me speaks to, again, that need to have a continuum of care, I guess, to employ a term that's used within medical settings, where there are practitioners that can offer quality care for different needs, depending on the issue, depending on the concern, for different folks. So Jennifer laid out the big areas of need at the beginning, but I wanted to speak a little more specifically to some of those areas, as well as the types of services that might be involved. So the legal needs assessment talked about housing law, family law, and immigration law as the top areas. Within housing law, respondents ranked foreclosure, mortgage-related servicing issues, eviction, housing conditions, issues with needs for repair, and tenants' rights highly. Within family law, domestic violence, child custody, child support, and divorce were the highest areas of need. Within immigration law, most of the categories actually ranked equally high by the respondents. So representation at immigration hearings and deportation proceedings, problems resulting from not having a driver's license, deferred action for childhood arrivals, and a whole host of other civil legal needs that are experienced by individuals that lack documentation. It is important to note that 80 to 90% of people in immigration courts, according to the legal aid programs that we work with, are not represented. I would note that the study validated what other states seem to have identified in their rollout of rules or proposed rules, that family law and housing law are two areas of high need. Rules or proposed rules in a number of states, Minnesota, Colorado, Utah, all these states seem to be focusing on housing law, family law, or both. As to the types of services that would address those needs, where could paraprofessional models provide effective, high quality assistance along this continuum of care? I did want to pose one question. This is not a question that we have data to speak to, but this came up recently on a national call of funders. What if we knew where along the way in the case were pro se litigants facing the biggest barriers? Data could help target ways to address those specific needs. I believe that there's some early studies which might be in the works in other states on this question. So it may be that we would have that information at some point, but is it before filing? Is it after filing but before service? that's a question that would help to identify where the missing points are, where are the weak points, and where could some support help people to be more successful. There's a host of services that you see here that rules or proposed rules in other jurisdictions are identifying as opportunities for support in areas of high need. One that's not included, but of course, the start interviewing a client to understand their needs, document preparation, filing service. The Arizona Legal Document Preparers Program does many of these things, preparing or providing legal documents, giving general information pertaining to rights and procedures, options, helping to file, helping to arrange for service. Explaining documents and helping to obtain documents, I think, is an important one. This includes reviewing the documents with a client, helping explain what a document is requesting. Utah's proposal includes many of these elements as well, stopping short of that final element of presence at proceedings. But I did want to note in 2 different states to speak to that last piece. In the Colorado proposal, presence at proceedings is limited to answering factual questions from a judge, taking notes, providing emotional support, helping the client to understand what it is that's happening. In Minnesota, which has only recently launched their 2 new efforts, paraprofessionals are allowed to appear on behalf of the litigants in limited proceedings, including in landlord-tenant, in some family law cases, including child support modification, pretrial hearings, informal proceedings, paternity matters. So there's a whole host of different services that might be considered. You all heard from the legal aid providers during the fall when a couple of folks joined. And just as a reminder, legal aid programs do currently use paralegals to provide representation to parties in certain administrative law settings where it is already allowed. They're trained and supervised by lawyer staff, but they can attend and act as a representative of the client, for example, in Social Security disability and for folks that are accredited representatives for immigration proceedings. I just point that out as a reminder to acknowledge that there's settings where this role and capacity is playing, paraprofessionals are playing an important role in providing quality assistance.
All right. I see our time is running short, so I'm just going to hit the highlights over the next couple of slides here. Court navigators. So I know this is an issue that you have heard about from other states. I also want to call your attention to the really terrific Mary McClimate report on this, where she studied 23 programs in 15 states in the District of Columbia. Things for you to keep in mind from a regulatory standpoint, right? So there are very few programs that have the formal authorization to deploy navigators in the court, such as a judicial order, regulation, or statute. These are often far more informal than that. It's legal information versus legal advice. And I know that is a line, that's another, I know it when I see it. I think providing greater definition around that, and one of the ways that the authors of this report have done that is, you know, are they advising can do versus should do? And that seems to be that line for a lot of these programs, but they facilitate access to justice for self-represented litigants. And it makes court processing more efficient. So, you know, there's a great advantage, I think, to the system to have navigators who help provide some of the logistics and the accurate forms and working through the volume and improving the procedural justice that can be incredibly beneficial without necessarily engaging in the practice of law. And I'll leave it to this group and the State Bar generally to define where that line is. But there's a very important role, as Mary's already pointed out, the continuum of care, right? You don't wander into a hospital and get yourself in the operating room, right? You've got somebody to meet you and take you every step of the way. And we need something similar through what is a very intimidating process to walk into a courthouse and to acknowledge how immediately hostile and adversarial that can seem to you when you are really seeking to preserve some of your, basic human needs, as we've already described. So we're sort of adding on layers there of additional anxiety and stress and really lack of access. So Mary, I'll turn it over to you for the next slide.
Sure. So again, we'll try to be quick here. The main highlight that I wanted to hit here in this sort of intro about potential tech solutions is what do we learn from the legal needs assessment that might shed any light on this? And I think the main points are that legal needs assessment did identify that community education was among the top need for services. This goes to education about the substantive law, about folks' rights and responsibilities, but also about process and procedure and available resources that might help them. The other point that I want to make, and this, I'm not sure that this made it into the executive summary, but in the longer report, it does document the fact that people search for information online. That might seem obvious, but in the same way that I, as a non-medical professional, I'm trying to look at my symptoms of illness by the internet, folks are looking online. The survey asked clients how they go about getting the legal advice when they need it. The most common answer was call a legal aid organization, but the second answer, coming very close behind it, was that clients or potential clients look online for self-help resources. This holds true across income levels. So folks at all income levels said they look online. Other ways of seeking advice, calling the court, going to a library, watching a video on YouTube, calling or visiting a social service agency, those were ranked much lower in terms of ways that people might seek assistance. I think that's the main point that I wanted to hit there.
Thanks. I appreciate it, Jennifer and Mary, and I know you may have some more. I want to leave us some time for discussion. I know we're scheduled to end at 4 o'clock. So let me open it up because there may be questions for Jennifer and Mary on these or other comments going back to the survey responses that we had in terms of the general discussion. So we may not have time in the next 12 minutes to fully explore it, but I really would like to hear from committee members in terms of either where your thoughts are in terms of where we are in the process, you know, kind of comments on where you are and where you'd like to see us go so I can effectively plan our future sessions. So I'm just going to open up the floor. You can either just speak or you can raise a hand. Mac, I see you're unmuted. Does that mean you want to speak?
I think we're probably ready to start talking about at least the top 3 issues on the survey where it appeared that there was, if not consensus, at least a substantial majority of us ready to dive in on some of those items.
Great. How about other thoughts on those? Is that where we should start, kind of those top 3 issues? And again, as a reminder, that is the limited license option, the court navigator option, and perhaps restriction, you know, maybe in conjunction with those two, relaxing some of the UPL restrictions. Camille, you're unmuted. Go ahead.
Yeah, I was going to say, I feel like we've done such a good job of the educational piece. I think we are ready to move on to a more action-oriented, you know, plan moving forward. And I thought the numbers looked good for those survey results for those top 3. So I certainly support starting there.
I think it's important that we, at least, you know, when we're thinking about what we're going to recommend or whatever, you know, form it takes, like we have those top 3, and I think that's pretty clear. But the next 3 include a ton of maybes, which means we don't have enough information. And so, you know, I would think some part of our, you know, moving forward is figuring out ways to get that information to the appropriate decision makers, because if we don't have enough after this year-long process, you know, how do you think, you know, they're feeling?
Jeff, let me ask you a question about that.
Yeah.
I said maybe on a couple of things, not so much because I needed more data, but because I needed to hear the discussion from the folks like you who have a lot more experience in this issue. But I think I've got a lot of information. I'm ready to hear the discussion.
No, I mean, I think that's great, actually. And Mark, maybe this helps you, plan a future meeting where we just have a group discussion of the high maybes, where people can bring their various expertise in and help, the rest of us figure out, okay, is this going to push me to a yes or a no?
Yeah, I think that makes sense, right? I mean, I think if we think we're done kind of the education piece, I envision the next few meetings taking these top, and I agree, we probably need to discuss the maybes, right? And have that discussion on, because I could see saying maybe, it's worth future exploration. We don't have to give we can say, the bar should consider these three and may want to consider these three, but I think having that dialogue to see if there's a consensus of where we stand would be valuable. So I do want to have that. So I think that's a good idea.
Joshua, have a comment.
Go, Josh. Joshua.
Yeah, so I don't know whether it's the right context, but 2 presenters ago, she made a point of saying there's already direct impact for non-lawyers acting under the direct supervision of lawyers in certain settings. At the last meeting, I asked the presenter whether that body had considered emulating or adopting or considering the system used on the medical and the physician world, similar to PAs, where they act under the license or the control of an MD. And she said no. But today we heard where there's instances where individuals that are not lawyers are doing that and they're having an impact. So to me, that's one of the things, whether I'm saying this at the right time, that I need to know why that's not something that's being considered or discussed more by the folks that we're asking to talk about this. What's being presented is that's not one of the options, and maybe I'm not saying that the right way. I apologize.
So, thank you, Joshua. I have some thoughts, but let me see. Alicia, is that something, do you want to comment on that? As I understand the question is, obviously, right now we've got paralegals, and I think the example is legal aid paralegals that work under the supervision of legal aid attorneys and do some of that work. This is a new proposal to create some things you can do without supervision. And I think the question I hear from Joshua is, how do those interface in terms of what can be done under supervision of attorney, perhaps under the current system, versus what we're considering with the new limited license model?
So my opinion is, I think that you're dealing with 2 different types of structures. I think the pay model is much different in the medical field than you see in the legal field. I think the money flows differently. I also think that you already have attorneys who are strapped for time and resources. And I think that will act as another barrier to access if you're saying we need someone to supervise the work that you're doing. I feel like you're going to have difficulty finding an attorney who wants to be on the hook for someone else's work. I'm not saying that that should be completely off the table. I just think that they're just completely different models for the way of doing things. I don't like with the medical field, you've got insurance companies who generally are the primary payer. You're not having that kind of issue in the legal field. So if you're going to bring in the attorneys as part of the process, does that make that service more expensive? Is that cost, I'm assuming the attorney is going to want to be compensated for his time, and overseeing this other person. Is that cost going to be passed down to the consumer? So I just don't know what that would look like.
Yeah, thank you. I think it's interesting. And I'm not an expert on the medical model too, but obviously it is interesting too, because they've got different levels of licensure in terms of, licensed nurse practitioner, other things that they do have different tiers of responsibility and different levels of licensure, and certain things you can do, without supervision, and others you need supervision of a physician. But I think you're right. The payer system is also pretty different, and I'm not sure one we want to try to emulate. It's a mess from a medical model in terms of the payment thing. But no, thanks. Good question, Joshua. Appreciate that discussion. Other thoughts on maybe where we are on the process in the last few minutes, other things you want to see in our next, few meetings as we begin to move towards a wrap up of our year-long work, as was noted earlier.
I see Jeff Kelly has his hand up.
Go ahead, Jeff.
Yep, I flagged it a little bit in chat, but the kind of open question of, all right, we have 3, I think, really supported and no opposition, but the maybes are kind of the open question for me. Is there something that either, those of us, full disclosure, I voted yes on the regulatory sandbox, and I am very familiar with the Utah office and a lot of the work that they're doing. What can I or other committee members put together that would address, I looked at some of the specific questions that seem to be logistical and funding for the sandbox, for example, but I would like to kind of open the floor and see if there are other areas of information that if I could compile that or others, we could ask for. Lucy Rico from the office spoke to us in November. So, what can we do to move that forward now that I think we're at more of a decision point to make sure that, this is something that the maybes feel comfortable either switching to yes or no, because I would hate for the maybes to be a soft yes and that not to be recommended. So that's my thought on it.
I think that's a great point, Jeff. And I guess what I'm envisioning, we've kind of had this educational piece. I almost envision a shifting into more of advocacy, may not be the right word, but where you would say, hey, I really think regulatory sandbox is a good idea. Here's why. And have a discussion, have someone else say regulatory sandbox is terrible for North Carolina and here's why. And then we have that, and again, and then we have that dialogue, and then we would actually kind of vote in terms of, so now you give it a thumbs up, thumbs down. Do we want to recommend this to the issues committee as something worth exploring? That's what I envision kind of getting to that vote. I agree. That's why, the survey was a straw poll, as it were, to get a sense of, do we have a consensus on some things? And again, I think the idea of at least exploring some kind of limited licensure is one where we seem to be fairly uniform around. This is probably worth moving forward with. Although what that recommendation looks like and what we want to say around it, I think we're going to have some good discussion on that point as well. But that is kind of what I'm envisioning, I guess, is now we take up those recommendations, and maybe we do that for all the categories. We may not have a lot of dialogue about the bottom 3 if no one is saying this is something we should do. Alice, I see your hand.
Yeah, so what I'm wondering, Jeff, if I'm understanding you correctly, you're sort of saying what things could I pull together in terms of information to help the committee consider whether the regulatory sandbox is a good idea. And so what I'm wondering, Mark, is maybe for this next step, if we want to break into like little, maybe smaller groups to tackle some of the maybe categories. I mean, I think it's pretty clear that there's a strong feeling that a paraprofessional, although the parameters of that are very unclear, but that is something that everybody feels like this has real potential. And maybe we take the other maybes, because, for example, Jeff, the regulatory sandbox, because UPL law, unauthorized practice of law is statutory in North Carolina. It creates this real question of, well, how would we create a regulatory sandbox without going to the General Assembly? And the answer to that is, would the Supreme Court be willing to do something? So there's a lot of political and legal questions there that maybe a smaller group of us could kind of grapple with initially, so that we could come back to the larger group and say, okay, we looked at this and here's the only way it'd be possible, something along those lines. So maybe like groups of 3, something, Mark, based on people's interest.
I like that idea a lot. And we'll figure out a way to ask you, but I may ask folks to tell me what of these small committees you kind of want to work on, and then our next meeting could include reports from this. I see a couple other hands. I saw Ashley Campbell first, then Jeff Summerlin.
Thank you, Mark. So the one thing I wanted to say is, I think to have a really good generative discussion, I think it would be better to do it in person. I know that's not a decision we have to talk about right now. You guys have state bar rules and regulations, but I'll just go ahead and say that. I think that
would really be a great, this would be a great meeting to do in person.
Is a great point. And we are actually in July, you know, the state bar is open to have in-person meetings of some committees. It's very limited. So this committee is not currently planning to meet, although conceivably some of these small group meetings, if we can find time to do it, might be able to take place in person. Yeah, I totally with you, Ashley. I'd love to do this in person. I mean, we've gotten good at this from a tech standpoint, but talking to you one-on-one, particularly as we get into kind of decision-making, would be really great. Jeff Summerlin Long?
Yeah, first, I would say the in-person thing would be fantastic. And, you know, maybe this is just the teacher coming out in me. You know, we all have people who've done like group study sessions. And group study sessions are useless unless you've studied before you go to them. And so what I'm wondering is if, not to add to people's burdens, but if we can maybe assign a little homework. Where people who have expertise in certain areas, who are advocating for certain, you know, solutions or paths forward, if they can, you know, go ahead and provide the committee with electronic resources, then I think it would help guide the discussion, whether we do small groups or the whole group at once. I don't really think it matters either way. But I know that, you know, I certainly would be willing, you know, to put together, you know, stuff that I'm familiar with and send it out to the committee. And I don't know exactly how that would work. And maybe, Brian, it's putting a little bit of an onus on you in terms of emails and that kind of thing. But I feel like we've covered so much ground. And there's so many different ideas out there, and we've heard from so many different people. I think it would be useful to have a sort of centralized compendium of information on each topic, and we can divvy this up amongst ourselves.
Yeah, that's a good suggestion. And I think we can work on figuring out like a resource center or how we want to provide that stuff. But I do think that's and we do. It's been a year, and I feel like we should all get some kind of college credit for it. But you know, we've learned stuff for a year, but there's a lot more out there and a lot of other reading to do. I know we're at 4 o'clock. I'm happy to continue a few minutes if you need to drop off. Thank you so much for joining. Who else wants to make a comment though? As we this is very helpful to me as I figure out what our next step should be as a committee process-wise. So I really do appreciate these comments and input.
Well, Mark, I was just going to add, as far as something that we can do, certainly from staff perspective, talking about the maybes. I feel like a lot of the conversation has been about the maybes, and just reading some of the individual comments on those topics. It struck me that there was some interest in kind of let's see what happens in those other jurisdictions. So there are ongoing efforts in other jurisdictions from which we can learn a great deal. And you know, when we think about it, we spoke with Lucy Rica in November. There's been quite some time that's passed between now and then. So I'm going to, after hearing everybody's comments here, I'll reach back out to Dave Byers in Arizona and Lucy in Utah, and just to see kind of where they're at. I know it's not like it's been 2 years that they have just a mountain of data, but there might be some additional information that we can bring here, and I think that might be a helpful thing for our next conversations, whether we're talking about working groups, or people bringing stuff to the table, just to again flush out the ideas to see, are these maybes maybe no or maybe yes, and move forward from there. So I'll put that on the task list.
I think that's great. Mac?
In addition to that, could somebody, Brian, maybe you, write just a couple of sentences about each of the items so that we start with a common understanding of the question we're asking? It's like, do you support, and then write out just a rough sketch of it so we have a good starting place.
I'll be happy to do that, Mac.
Or Brian, can you share the results of our survey with us? Because I think that also asks some questions about each of these components. Is that something we can see?
Yeah, the survey results should be in your materials for today's
okay.
agenda. Yes.
Okay. I didn't get all the way through. I'm sorry.
Yeah, no, it's all right, including the individual comments. So that should be helpful as well.
Okay. And then the other thing I would say, one of the reasons I jumped so quickly on, yes, let's move on the first three, is because I would love to see us take some action and not, sit around for a year to work on a report. And that's just, that's just a sort of a personal preference. But I'm real big on a sandbox idea as well. I mean, it's not that I was probably yes on all of them, and none of you would be surprised to know that, right? So I'm definitely interested in these, but I was hoping we would, make sure that we kept some momentum going. And so if we felt like we could move further quicker on one or two while we continue to research and study and write beautiful reports.
I agree with you 100%, Camille. And I think there's a way to, if we go kind of in that priority order with the survey, that's one of the reasons I wanted to get a sense of where we are. I do think it may make sense, and we can figure out how these smaller groups tie into it. But I think we should focus on them in that order and kind of decide on a recommendation about what we want to do on paraprofessional models. We can do that before we go to the other, before we take up sandbox. And again, we can make, I think some discussion on all of them makes sense, but I'm with you, that probably makes sense to go ahead and do that. And if it really looks like it's going to be a while, we can make a recommendation in one report and do a second report as well. I am, it is challenging because we're all busy and we've had a number of meetings, but I'm with you. I want to try to, have accomplishment too. And, my goal has always been to try to get a report over to the issues committee certainly by October, if not before. And we need time we're going to have time to review and vote on and decide on that report. So I want us to move expeditiously. And I appreciate that comment. I'm looking. Any other hands, Brian? I don't see any, but this is.
I don't think so.
Great. Thank you guys so much. I mean, this is good. We obviously have a lot more to discuss. There was a great presentation today. It ended up taking some of our discussion time, but I think it was important to see those results as a continued driver of where we want to get to. And I appreciate that. And I'm sorry to just have to cut it short, Mary. I know you guys weren't quite, and Mary and Jennifer, we're not quite done, but we're balancing, those needs. But this is great. I appreciate the guidance, and I think we've got good info on where to go next. So I appreciate it, everybody. And we'll definitely be meeting again, in June for sure. We'll send you times. I think if we can also get more done. If we don't, we'll meet at least once a month. If we can squeeze in an extra meeting or two, I'm in favor of it because I think it's important work. So thank you guys.
All right. Thank you, Mark.
Great.
Thank you, Mr. Chairman.
Great. Good to see you all.